Hi, I am Shaj, and today I'm going to talk about an interesting but altogether shameful case in human rights that's regarding Abigail de Los Santos and Monitor Marketing versus Monitor Marketing Solution Incorporation and David Singh. This case is about the harassment in employment because of the sex. In this case, the applicant alleges discrimination with respect to employment because of sex, including sexual harassment. That is contrary to the Human Rights Code 1990, which is also better known as D Code. Facts of the case goes like this. The applicant commenced employment in the organization on July 22nd, 2013 and worked there for 6 months as an executive assistant. Now, the vexation and sexually inappropriate behavior started from the very first day for Abigail, where instead of shaking her hand, the personal respondent gave a tight hug to the point of trying to feel the applicant. Respondent, in one instance, eyed Abigail from top to bottom, concentrating on her legs. In August 2013, while hiring a new candidate, the respondent advised to the applicant that we should hire someone who is hot like you. August 7, 2013, the respondent placed his hand on the calf of the applicant and rubbed it upside down and saying that if I had such a great legs as you have, I would also wear a skirt. So such shameful remarks were continuously made, and Abigail felt subjected to being sexually harassed. Uh, so, subsequent to the application which is made in the Human Rights Tribunal of Ontario, the respondent showed complete absence in all the proceedings. The chronology of the notices that the respondent did not order are given below. Are March 27, 2014, September 15th, the respondent didn't show up or neither responded to any of the notices. So, the respondent failure to provide any notice, respond to the notices, an interim decision was passed. After that, on January 26, 2015, a case assessment direction was taken. Another CID was conducted on February 13, and in both the cases as well, the tribunal made sure that the respondent gets the notices by mailing to the respondent's correspondence address as well as to the personal mail. But this time also the respondent didn't answer to any of the notices. Therefore, it was deemed that the respondent has failed to give answer to the notices and therefore accepted all the allegations that are set out in the application. Relevant legislations in this regard. So the first section of the Human Rights Code 1990, which is breached in this case, is section 5.1, which says that every person has a right to equal treatment with respect to employment without discrimination because of race, ancestry, place of origin, color, ethnic origin, citizenship, creed, sex, sexual orientation, gender identity, gender expression, age, record of offense, marital status or family status, or disability. Another section which is breached is section 7.2, which says that every person who is an employee has a right to freedom from harassment in the workplace because of sex. So, the tribunal provided the decision, which is 20,000 in monetary compensation to Abigail, and also directed that the organizational respondent shall provide training to the personal respondent and other management and employees on the code with respect to sexual harassment. I would particularly like to focus here that it's good that along with the monetary compensation, the tribunal is also decreeing on the training which is compliance to the code, so that the people who are negligent to the code are no more negligent, and they get to know that their unacceptable social behaviors related to the all the uh, factors noticed on the section 7.1.2 of this tribunal is not unnoticed, and they are highly liable in terms of law. Another interesting factor in deciding monetary benefit is, while the respondent's business may be small, but the tribunal is mindful that they cannot trivialize the social importance of the code by setting the monetary compensation too low and create a license fee to discriminate. To analyze, the Canadian society is becoming increasingly more and more equitable, and that means more and more women are going to be there in the workplace. This case is from 2014. That means it has been like 3 decades since the enactment of the code, and still we are, uh, after 30 years, we are having the sexual harassment cases being raised in the tribunal. So somehow we are lacking some efforts in properly executing the code. So I would say that some ferocious execution of the code would, is definitely the demand of the time, and such cases will help in making sure that such filthy mentality will no longer be tolerated, and eventually it will pave the way for ideal working conditions for everyone once we are successful in curbing such shameful behaviors. Now, in conclusion, I would like to quote the code itself. The preamble goes like this: uh, recognition of the inherent dignity and the equal and inalienable rights of all members of the human family is the foundation of freedom, justice, and peace in the world. So, in order to maintain the peace and freedom and justice in the world, we got to respect each and every individual's dignity. We got to treat everyone equally, disregarding their creed, caste, religion, sexual orientation, or sexual identity, and all the other things which are mentioned earlier. These are so important that they were first declared in the Universal Declaration of Human Rights by United Nations. So I'm hopeful that in the coming time we will have some utopia where women will not be subjected to such sexually inappropriate behaviors. Thank you so much.